Good evening. I begin by acknowledging the traditional custodians of the land on which tonight's event is held, and I pay my respects to their elders past and present. I also extend that respect to Aboriginal and Torres Strait Islander people attending this evening. Thank you to the President of the Australian Law Reform Commission, the Honourable Justice Bromberg, for inviting me to celebrate the Commission's 50th anniversary. While my commitments during this parliamentary sitting week prevent me from joining you in person, I'm extremely pleased that I can join you virtually to mark this significant event. I send you all the best wishes for this evening's dinner and celebrations. Tonight, we reflect on the important contribution of the Australian Law Reform Commission to the Australian community over half a century. In 1973, the then Attorney-General Lionel Murphy QC introduced legislation in Parliament to establish the Commission. Now, while some may claim the best investment the government made in 1973 was the purchase of Jackson Pollock's Blue Poles, I would argue that introducing legislation to bring the Commission to life is a close second. At that time, Attorney-General Murphy reflected that a purpose of the legislation was to see that the system of law under which people live is responsive to the social needs of our time. He said that the rules which govern the relationship of persons with each other and with the government should reflect current values and philosophies. These objectives remain as important today as they were 50 years ago. The rule of law requires laws to be clear, predictable and accessible. To maintain trust in our legal system and institutions, laws must be responsive to the evolving needs, values and expectations of our contemporary society. As the Honourable Michael Kirby, inaugural chairman of the ALRC, put it, the flame of law reform affirms a central concept of the rule of law itself, legal renewal. To achieve this, the Commission makes recommendations to bring the law into line with current conditions, remove defects, simplify the law and improve access to justice. At a time when technology is rapidly developing and changing the world around us, this advice is critical. A key strength of the Commission is its ability to provide independent, expert and rigorous recommendations on the diverse range of issues that affect Australians. In its 50-year history, the ALRC has delivered some 80 inquiries on topics as wide-ranging as evidence law and family violence, managing discovery in federal courts, elder abuse and privacy law. The ALRC's recommendations have real impact. To take one example, in 1987, the Commission recommended modernisation of the rules of evidence, which it described as a highly complex body of law containing many areas of uncertainty, traps and pitfalls. The Commission's draft bill formed the basis of the Uniform Evidence Law, which continues to apply in courtrooms across 6 Australian jurisdictions today. The breadth of the Commission's work is reflected by the 3 inquiries it is currently conducting on surrogacy laws, the Future Acts regime in the Native Title Act, and human tissue laws. These are topics of significant importance involving social and legal issues which affect members of our community every day. As Attorney-General, I am focused on delivering priorities that will make a positive and tangible impact on people's lives. The government wants to deliver change that makes a positive difference, and law reform is a critical component of achieving this. I look forward to continuing to support the work of the Commission in pursuit of these ambitions. In closing, I acknowledge Justice Bromberg, current and former Commissioners, former Presidents and staff at tonight's event. Thank you for your valued contributions to delivering on the important work of the Commission over time. The Australian community has been well served by your independent law reform advice. Congratulations on this most considerable milestone.